Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 2021 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On November 8th, the court heard argument in Unicolors, Inc. versus H&M Hennes Mauritz. Joining us today to discuss this case is Professor Z. Rosen of Southern Illinois University School of Law.
On November 8th, 2021, the U.S. Supreme Court heard argument in Unicolors, Inc. versus H&M Hennes Mauritz, LP. The question presented by petitioner was, did the Ninth Circuit err in breaking with its own precedent and the finding of other circuits and the Copyright Office in holding that 17 U.S.C. Section 411 requires referral to the Copyright Office where there is no indicia of fraud or material error as to work at issue in the subject copyright registration? My name is Zvi Rosen, and I'm a professor at Southern Illinois University School of Law. I'm going to take a few minutes to explain what that means, how we got here, and maybe where we're going. I also wanted to caveat that I signed the brief filed by Professor Tyler Ochoa in support of Unicolors, so while I don't have any conflict regarding this case, I put my view of a proper result of this in this case on record. Section 411A of Title 17 of the U.S. Code states that, subject to caveats that aren't relevant here, no civil action for infringement of the copyright shall be instituted until registration of a copyright claim has been made in accordance with this title. An action may also be brought if the application for registration was rejected, but not if the application is pending. In 2008, Congress added to this section as part of a Pro-IP Act. The new Section 411B provided that a certificate of registration does not satisfy the requirements of Section 411 if inaccurate information was included on the application for copyright registration with knowledge that it was inaccurate. Remember, knowledge is a key word. And the inaccuracy of the information, if known, would have caused the Registrar of Copyrights to refuse registration. If inaccurate information is alleged, the court shall request Registrar of Copyrights to advise the court whether the inaccurate information, if known, would have caused the Registrar of Copyrights to refuse registration. This section was made to clarify the judgment doctrine of fraud in the Copyright Office, where a registration was invalid if procured by fraud. The House report makes clear that this section of a Pro-IP Act was intended to deter claims in litigation that a mistake in registration documents, such as checking the wrong box on a registration form, renders registration invalid and thus forecloses the availability of statutory damages. This all became relevant when Unicolors received a copyright registration for a group of patterns in 2011, including one entitled EH101. In 2015, the fashion retailer H&M brought out a jacket using an allegedly similar pattern, and Unicolors brought suit against H&M. Creating and licensing patterns is what Unicolors does, and the brief filed by H&M accuses Unicolors of being a quote-unquote copyright troll, along with an amicus brief filed by 12 law professors filed in favor of H&M, which discusses concerns of what they call copyright trolling more broadly. Now, others have disputed this characterization of Unicolors and their business model, but this would come up at argument, so it's worth mentioning. Rather, the issue in the case is really the accuracy of Unicolors' application for copyright registration. In the application, Unicolors inaccurately represented that all the works were published on the same day, which did not turn out to be accurate, and in fact, 9 of the works had not been published at all. There was some question whether the works were placed in a showroom and shown to prospective clients, but not offered for sale. The jury found in favor of Unicolors for close to $1 million, and the district court declined to refer the matter to the Copyright Office under Section 411B, holding that Unicolors' copyright application had met the requirement that all units constitute a single unit of publication. On appeal to the Ninth Circuit, though, the Ninth Circuit held that no evidence of intention to defraud the Copyright Office was required, and that because the designs had not been offered for sale at the same time, they did not qualify as a single unit of publication, and thus the application was inaccurate. The court found that Unicolors knew the information was inaccurate, and no inquiry into whether Unicolors understood the legal significance of this inaccuracy was needed. So this takes us back to the question presented, which I'll read again. Did the Ninth Circuit err in breaking with its own prior precedent and the findings of other circuits and the Copyright Office in holding that 17 U.S.C. 411 requires referral to the Copyright Office, where there is no indicia of fraud or material error as to the work at issue and makes subject to copyright registration? Notably, this does not look to the meaning of knowledge. You don't see knowledge mentioned there at all, and it's instead focused on whether the matter should have been referred to the Copyright Office. However, the question of knowledge became front and center even as H&M protested, and the court has strayed from the question presented. Unicolors argues that a mistake as to the legal significance of an action cannot constitute knowledge, and both Unicolors and Amici know the context of a Pro-IP Act, which added Section 411B to the copyright law, and the Pro-IP Act was explicitly meant to help, not hinder, copyright owners in their desire to get a return against infringements. The U.S. Copyright Office also filed a brief and argued for a similar rule. For its part, H&M argued that actual or constructive knowledge was sufficient, and mistake of law is no defense. This is where Unicolors' history of copyright litigation may be relevant. If they've been a party to hundreds of copyright lawsuits, H&M argues they should have known better. But this ended up not being a major issue at argument. In truth, at argument, one got a general sense that the case was undercooked, and the court was searching for a way to dismiss the case and say that the petition for writ certiorari had been improvidently granted, a so-called DIG. Following the Ninth Circuit's decision, the case probably should have been remanded to the district court, which would have in turn referred the matter to the Copyright Office, and key questions could have been answered regarding the case. H&M's repeated notices if a question presented was not the case being argued likely had an effect on the court as well. The argument had some fascinating moments, though, including the deepest discussion of the meaning of publication before the Supreme Court in some time. Although this will not be the case to do it, the fact that the government was unable to say for certain whether displaying a fabric design in a showroom constitutes publication is surely a healthy reminder of the complexity of a law regarding publication. Scholars and lawyers have been urging an abandonment of a published-unpublished distinction in copyright law for some time, and perhaps this confusion before the Supreme Court will hasten that development. That said, assuming the case moves ahead normally, there's a general expectation that the argument of Unicolors and the Copyright Office will be adopted. A limited decision along those lines, coupled with a remand to the district court to figure out some of the questions which were undercooked for the Supreme Court, wouldn't be a surprise at all. So this has been Zvi Rosen of Southern Illinois University School of Law, discussing the case of Unicolors Inc. versus H&M Hennes Mauritz Inc. regarding the question of what knowledge within the meaning of 17 U.S.C. 411 is.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.